Hello and welcome. We've got a new motion from the prosecution. It was just submitted today, March 17, 2025. It's a wild one, guys. Hold on to your seats. Okay, it reads Commonwealth's motion for buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. During the defendant's first trial, the court established a buffer zone in which demonstrations were prohibited within 200 feet of the courthouse complex. The Commonwealth requests this buffer zone be reestablished for the defendant's upcoming trial, but with two important modifications. First, on the western side of the courthouse facing Court Street, the extent of the buffer zone was inadequate to prevent such demonstrations from jeopardizing the integrity and fairness of the proceedings. The demonstrations could be heard inside the courthouse, including by the jurors during their deliberations. To prevent this from reoccurring, the Commonwealth requests that the buffer zone be extended to include the area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. Second, the Commonwealth requests that the court's buffer zone order expressly include a mechanism for its enforcement where a person is believed to have violated the buffer zone provision and has refused requests to comply. Law enforcement personnel should be authorized to use reasonable physical force to arrest that person to ensure compliance. That's right. That's right, guys. No freedom of speech here. No freedom of expression here. No right to protest here. No right to tell the world that they are yet again trying to prosecute an innocent woman for a crime in which she is provably not guilty of, right? They don't want supporters wearing shirts or signs. They don't want supporters anywhere around the Superior Courthouse. And they want Judge Bev to give law enforcement authority to pull these supporters off from the area if they want to. You know how that discretion goes. If you guys follow enough protests, if you follow enough demonstrations, you know what happens when law enforcement is given discretion to shut someone up during a protest. And more often than not, it is members of law enforcement who are creating the violence in protests and demonstrations. It doesn't matter how peaceful the protest is. All it takes is one cop high on power. All it took was one cop high on power to do this to John O'Keefe. You know, good cops don't survive around bad cops. What happened to John O'Keefe is what happens to good cops when they are around bad cops, right? Craziness, guys. I'm going to reread that last sentence. Second, the Commonwealth requests that the court's buffer zone order expressly include a mechanism for its enforcement where a person is believed to have violated the buffer zone provision and has refused requests to comply. Law enforcement personnel should be authorized to use reasonable physical force and to arrest that person to ensure compliance. Additionally, the Commonwealth requests that the court again order that individuals are not permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case or to any trial participant in the courthouse during the retrial. Again, guys, I don't get how this is okay. Why do you got to go that far, Hank Brennan, Michael Morrissey, Adam Lally, McLaughlin? Why do you all got to go that far? It's like we're back in the 1940s or 1950s, and this is like a dictatorship, and we're all being supervised by dictators who don't want us uh, expressing ourselves. They don't want us telling the truth. They don't want us protesting. They don't want to see the Karen Reed supporters, and they don't want the Karen Reed supporters to feel like they can be seen or they can be heard. And they clearly want to scare the supporters. They want to scare the protesters. It's not cool, and it's shitty, and it's cowardice. It's like they know they're losing. They know they're going to lose again. And instead of giving up and just telling the truth that this was a cover up in which multiple members of law enforcement conspired between each other to pin this on Karen Reed so that other members of law enforcement could get away with what happened to John O'Keefe. Like, the whole world doesn't know that. Like, 80 to 90% of people following this case don't know that. They're losing. The prosecution is losing. Judge Bev is losing. None of them are going to get their reputations back after this is all over. So this is yet another last ditch effort to control the truth. Because if you can't see the protesters and you can't read their signs and you can't see the photographs they're holding up and you can't read the words that are on their clothing, and if you can't hear them, what is that other than censorship? What is that other than silencing the truth sayers? What is that other than trying to hide the truth, which is exactly what this entire case is? It is one grand scheme to hide the truth. Their freedom is really that much more important to them, guys. The McCabe's, the Alberts, Brian Higgins, Michael Proctor, Nicholas Guarino, Michael Morrissey, Judge Beverly Cannoni, all of them. Their freedom is a lot more important to them than Karen Reed, than John O'Keefe, than John O'Keefe's family, than Karen Reed's family, and than anyone who is deeply affected by this case. They care more about their freedom and about their selfishness and their corruption, and about the ability to keep living corrupt and keep living selfishly. They care more about all of that than about the truth, than about doing the right thing. And if they really think that this is going to silence the supporters, they have another thing coming. You know, it's when you attempt to quiet the people, you get the exact opposite in response. And there will always be more people than there are members of law enforcement. Always. So I'm saying, if anything, this is going to make more people come to the courthouse. This is going to make more Karen Reed supporters come out from all over the world to show that this is, in fact, a cover up, to express their true feelings about this extensive corruption. They can make it a court order all they want to, and Judge Bev can approve it all she wants to, but they are going to lose. Continuing, background. On March 26, 2024, the Commonwealth moved for an order barring demonstrations within a buffer zone of 500 feet around the courthouse complex and prohibiting certain items from being worn or displayed inside the courthouse during the defendant's first trial. A group of individuals moved to intervene in the case to oppose the Commonwealth's requests The American Civil Liberties Union of Massachusetts, ACLUM, sought leave to file an amicus curiae memorandum, essentially in opposition to the request. The defendant took no position on the matter. Following a hearing on April 4, 2024, the court denied the motion to intervene, granted the ACLUM to submit its memorandum, which the court noted it had read, and ordered that, quote, no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting, and no individuals will be permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the trial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department-issued uniforms or any police emblems in the courthouse. End quote. But remember, guys, remember Helena Rafferty? Remember when she came there with Paul O'Keefe just a couple weeks ago? Remember that? Because Paul O'Keefe's wife, Erin, Erin O'Keefe, wouldn't walk in with him, wouldn't sit with him after the world found out that Paul O'Keefe was cheating on her with someone online. Those shirtless photographs and the glazed donut reference. That Paul O'Keefe, yeah. Remember Helena Rafferty, the chief of police for the Canton Police Department? Remember? She walked right in with her uniform and 4 other Canton PD police officers. Remember that, guys? And there's the order right there, which the Commonwealth is citing. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department-issued uniforms or any police emblems in the courthouse. But Helena Rafferty must have been an exception to that, right? Nothing happened to her. Continuing. The would-be interveners filed a petition for extraordinary relief pursuant to GLC 211 subsection 3 in the Supreme Judicial Court for Suffolk County, challenging both the denial of intervention and the buffer zone order. Soon thereafter, a second petition under GLC 211 subsection 3 was filed by an association of individuals who wished to demonstrate in the buffer zone during the trial, and 2 members of the association. The Commonwealth opposed the petitions, and the defendant again took no position. On April 12, 2024, a single justice of the Supreme Judicial Court denied the petitions. See Memorandum of Decision and Judgment, copy attached as Exhibit B. The single justice held that the denial of the motion to intervene was, quote, an ordinary procedural ruling, end quote, not requiring the court's extraordinary intervention, and therefore denied any relief from that ruling. The single justice also determined on the merits that the buffer zone order passed constitutional muster and did not violate the petitioner's First Amendment rights. Specifically, the establishment of the buffer zone was a content neutral and reasonable time, place, manner restriction on speech that was narrowly tailored to serve a significant governmental interest, and that left open ample alternative channels for communication of information. The petitioners, that's how they summarize it, guys. Specifically, the establishment of the buffer zone was a content neutral and reasonable time, place, manner restriction on speech that was narrowly tailored to serve a significant governmental interest, narrowly tailored, that left open ample alternative channels for communication of information. Guys, I call bullshit on that. Left ample channels, like alternatives to express yourself, to, like, no, like, there's the Superior Courthouse and there are multiple court buildings surrounding it and a church surrounding it, right? And so what's the point of being there as a supporter if you can't be at the courthouse where Karen Reed's gonna be. If you can't, like, stand near it and represent her innocence, what's the point, right? So they're trying to eliminate all of that altogether. They don't like how much power the supporters have. Again, they don't like the truth. They are constantly fighting the truth in this case. Again, they're not gonna win. I'm not really worried about it. I'm just like, the gall, again, the gall, good luck, dude. Good luck, prosecution. Continuing, the petitioners appealed the single justice's judgment to the full Supreme Judicial Court. The Commonwealth filed a response. The defendant further declined to take a position. On April 26, 2024, the full court issued an order affirming the judgment, and on May 2nd, 2024, it issued an opinion stating the reasons for that order. See Specuzza versus Commonwealth. The court held that the single justice did not commit an error of law or abuse his discretion in determining that the denial of the motion to intervene was not a matter warranting the court's exercise of its extraordinary power of general superintendence. As the petitioner's constitutional arguments, the full court similarly concluded that the restriction created by the buffer zone was content neutral and not a prior restraint on speech. It was narrowly tailored to serve a significant governmental interest, and it left open ample alternative means of communication. Again, I disagree with the ample alternative means of communication. No, uh, especially guys, especially when the mainstream media like Court TV and Law and Crime, and ABC and whatever, all those other news networks that misrepresented this case, and I've thus refused to keep watching them. Uh, all of them were permitted to be in the courthouse, to be around the courthouse. The mainstream media is allowed to be there, you know? But the supporters have to stand in line for hours just to get a seat into the courthouse, just to, be lucky enough to get a seat. And those seats are limited on purpose. They will let members of law enforcement in, they'll let their families in, and they'll treat it like it's some kind of school field trip. Let's all go to the courthouse and see how this is going to unfold. An innocent woman's getting framed for murder. Such a good time, right? Like, that's how they all behave. And so the ones who think she's innocent don't get to go in. The mainstream media gets to go in. The ones who think she's guilty, they all get to go in. But the supporters who know that she is innocent, they don't get to go in, right? So keep pushing the ones who know the truth away, and keep letting the ones who propagate and lie, keep letting them in the courthouse. Yeah. That's how they do it at this courthouse. That's how Michael Morrissey likes it. Discussion. Continuing. The factual circumstances and concerns that necessitated the creation of the buffer zone last time are no less present or compelling today. This case continues to garner significant public interest and media attention locally and nationally, and is a subject of commentary on various social media platforms. The proceedings are still attended by groups of individuals demonstrating in front of the courthouse, displaying references to materials that may or may not be introduced in evidence at retrial, and airing their opinions as to the trial judge, prosecutors, witnesses, and the guilt or innocence of the defendant on their clothing or signage. Uh, the guilt or innocence, yeah, it's more so the innocence, guys. Like I've said, guys, there are maybe 10 people. When I've been to the courthouse, there were maybe 10, maybe 15 people who were there and were like, wearing the blue shirts and had "She did it," "I hit him, I hit him, I hit him" signs. But it's like 200 supporters who are there a majority of the time when the trial's going on. There's like 200 people. So I'm saying, guys, like, it's it's more so innocent, not really guilt. It's whatever. Okay, continuing. And in parentheses, despite the inclement weather at the hearing on February 6, 2025. Okay. Shown below, for example, are photographs of demonstrators who appeared despite the inclement weather. Okay. I find it interesting that they selected these, uh, and they depicted them. It's just weird. Like, why not show the entire photo? Like, why not show the real photo? Interesting. But anyway, Morris C. McAlbert, Federal Prison, 2025. Uh, what is it? Is it that they're bothered by this part, airing their opinions as to the trial judge, prosecutors? Is that what it is? They don't the judge, Judge Bev, doesn't like those signs about her, and Michael Morrissey and Hank Brennan and Adam Lally, they don't like the signs about them, right? Michael Proctor too. Is that what this is really about? They don't like it when people talk shit about them. Continuing, in addition, and as the court found when it issued the buffer zone order, protesters have shouted at witnesses and have confronted family members of the victim. Witness intimidation also remains a prevalent issue in this case, with additional criminal charges having been filed earlier this month. Yeah, Commonwealth versus Aiden Kearney, describing efforts by individuals to intimidate, harass, and doxters following declaration of mistrial. And that's not true. The reestablishment of a buffer zone is therefore necessary to help ensure that both parties receive a fair trial, free from outside influences. And guys, remember, Aiden Kearney got locked up because his girlfriend, his ex-girlfriend, was in direct communication with one of the lead investigators in the Karen Reed case. Okay, she successfully obtained a restraining order against Aiden Kearney after lying about him, and when she alleged that he violated that restraining order, she didn't contact her local police department and say, "Hey, my ex is violating my restraining order, and I need help. Can you guys come, please, come help?" She didn't do that. She contacted one of the lead investigators in the Karen Reed case because she knew by contacting him, he would immediately have, everything he wants. He would immediately get Aiden, lock him up, and then there's no one talking about the Karen Reed case. No independent journalist talking about the Karen Reed case, right? Mainstream media will run with it, and they'll paint her like she's guilty because they're clearly, in the prosecution's favor, right? Maybe the prosecution's got money in the mainstream media. Who knows, right? But it was a ploy. It was a strategy to have Aiden Kearney locked up over false accusations. Okay, guys? And again, those accusations, kept him away from his children during the holidays. Right? And it was a lie. And when she attempted to get the restraining order renewed, I was there in the courthouse at the district court in Dedham. I was there when she attempted to get that restraining order renewed, and it was denied. She wanted to keep Aiden Kearney on that restraining order so that at any moment she could just make a call and he'd go right back to jail. So I'm saying that was based on a lie. It was based on a lie in which an ex-girlfriend was in cahoots with one of the lead investigators in the Karen Reed case. And so sure enough, the prosecution wants to refer to Aiden as if he's a problem. Commonwealth versus Aiden, and he has additional criminal charges pending. But they are charges, they're not convictions. He has yet to be convicted, and they know better than that. They know better than that. Like, again, guys, like, how is it that there can be multiple members of law enforcement who were proven to be liars in the Sandra Birchmore case, and those members of law enforcement are also involved in the Karen Reed case, right? And we're supposed to believe they're credible, even though they were liars in the Sandra Birchmore case? We're supposed to trust them in the Karen Reed case, right? And we're also supposed to trust that their false allegations against Aidan Kearney are somehow a threat to this case or to the jurors, or that witnesses are gonna be intimidated when, again, there isn't one charge yet to date against Aidan Kearney for witness intimidation. These are all narratives. These are all things they're throwing out there to discredit Aidan, to discredit anybody who talks about Karen Reed being innocent. And I get it. Some people don't like Aidan Kearney. Some people don't like me. Like, it's, you don't have to be everyone's cup of tea, you know? Whatever. What's more important is the information. That's what matters. The communicating of information, right? And so this motion in and of itself is yet another attempt to control the information. Continuing. The reestablishment of a buffer zone is therefore necessary to help ensure that both parties receive a fair retrial, free from outside influences. They cite Commonwealth versus Underwood, in parentheses, noting the Commonwealth too has the right to and an interest in the defendant receiving a fair trial, and the buffer zone order also supported that right. During the first trial, the 200-foot extent of the buffer zone was adequate to prevent any demonstrations occurring on the southern, eastern, and northern sides of the courthouse complex from interfering with the proceedings inside the courthouse. See affidavit of Massachusetts State Police Sergeant Michael W. Hardman, filed herewith. On the western side of the complex, however, it proved to be inadequate. On that side, there are larger open spaces that extend beyond 200 feet from the courthouse, in particular, the paved and grassy areas along High Street between Bullard Street and Ames and Court Streets. These areas are shown in the Google Maps screenshot below, along with a red line superimposed to indicate the extent of the 200-foot buffer zone on that side of the complex. Okay, so Dedham Courthouse, Norfolk Superior Court. I'm gonna zoom out. Okay, so Ames Street, Bates Street, Bullard Street, and Norfolk County Superior Court is right there. Okay. Along with a red line superimposed to indicate the extent. Okay, well, obviously it's black and white. It's hard to see the red line. Okay, I'm gonna zoom in. Continuing, groups of demonstrations gathered in these areas, presumably with the property owner's permission, and engaged in coordinated shouting and chanting aimed directly at the courthouse. Even when standing just outside the buffer zone, these demonstrators could be heard inside the courthouse, including during deliberations. Affidavit of Juror Doe. During during jury deliberations, we could hear protesters outside screaming and yelling, end quote. As another consequence of the 200-foot extent of the buffer zone, individuals positioned in these areas were close enough to Court and Ames Streets to encourage passenger and commercial vehicles traveling on those streets to honk their horns as a form of demonstration. This happened repeatedly, with the honking, especially from the air horns of the commercial vehicles, could easily be heard in the courthouse. In connection with the first trial, the Massachusetts State Police issued more than 24 citations for horn violations and other motor vehicle offenses. Look at that, guys. The Massachusetts State Police, the MSP, were working. You know, they were issuing their citations, meeting their quotas. You know, they should be thanking they should be thanking the supporters. I'm laughing because it's their right. It's their right. It's freedom of speech. And by the way, taxpayers pay for those courthouses. Taxpayers pay for those sidewalks. It's, you know, it's not private property when it's a courthouse, right? I can't stand how they treat it, you know, and I've been there. I see how the court officers how they behave, how they treat the supporters, how they spot you as you're going. They knew immediately that I was a supporter. They knew immediately. I attempted to walk up the steps, and they asked me, uh, "Who are you here for?" And I said, "The Karen Reed hearing." And they're like, "You got to wait in line." And I'm not gonna bombard Karen Reed as she's arriving like some people do. You know, there are some people who bombard her, and it's like their only chance of getting a seat in the courthouse is to like immediately catch her when she's arriving in the SUV with her bodyguards and her attorneys. And sometimes if she's got room, she'll be like, "Yeah, just come on in," and you can walk in with her and sit. Certain people can walk in and sit with Karen Reed. But a majority of the supporters don't get to do that. A majority of the supporters have to wait in line, and they are absolutely seen from a mile away by the court officers. And the court officers go above and beyond to maintain control of the supporters. If it's the O'Keefe family, if it's the McAlberts, the McCabe's and the Alberts, if it's the MSP, and clearly, if it's Canton PD, they're all permitted inside without any issue, without any interference. But the Karen Reed supporters are absolutely discriminated against. They are prejudiced against. And this is yet more of that bullshit in this motion to completely eliminate them from the entire area, so they are completely out of camera view, and so that nobody in the courtroom can hear them. Like, so what if people are honking outside the courtroom? Like, we hear the ambulances going by during the trial, we hear the fire trucks going by during the trial, like, I'm saying, like, we didn't really hear the horns during the trial. We didn't really hear cars honking during the trial. So yeah, it's bullshit, yet more bullshit. Continuing. To maintain the integrity of the retrial proceedings and to prevent witnesses and prospective or seated jurors from being subjected to these demonstrations, the Commonwealth requests that the buffer zone on the western side of the courthouse complex be extended to include the area encompassed within Bates Court, Ballard Street, Ames Street, and Court Street. The extended buffer zone would range from approximately 300 feet between the northern ends of the complex and Bullard Street to roughly 400 feet between the complex and Bullard Street along High Street. This would bring within the buffer zone those areas where demonstrations undermined the buffer zone's very purposes, while at the same ensuring that demonstrators are not moved any further away from the courthouse complex than is necessary to prevent those same issues from recurring. Ugh. Continuing, it is narrowly tailored to address the specific problems that were encountered from experience at the first trial, and it will still leave open ample alternative channels of communication and outlets for demonstrations. Narrowly tailored, but these are several hundred feet we are talking about surrounding the Superior Courthouse. The word narrowly is not the word. It doesn't apply. They really want to play it down. It is narrowly tailored to address the specific problems that were encountered from experience at the first trial, and it will still leave open ample alternative channels of communication and outlets. Again, the narrowly tailored, no, and it will still leave open ample alternative channels of communication, no. Continuing, the Commonwealth also requests that the order reestablishing a buffer zone expressly state that a violation of any of the provisions of the order may constitute contempt of court, and that law enforcement officers are authorized to enforce compliance with the order by using reasonable physical force and arresting any person who officers reasonably believe to be in violation of the order and who has refused to follow officers prior verbal requests to comply. Officers will continue to seek compliance in the first instance through verbal requests and use of de-escalation techniques to the maximum extent possible. I'm going to read this footnote in the previous page, number 7. Number 1, this continues to be a demonstration tactic as shown in the above photograph of the individual at February 6th hearing who is holding up a sign that says honk for justice. Frequent honking has occurred at nearly every hearing held in this case over the past several months and has been clearly audible in upstairs courtrooms. Again, guys, I don't remember hearing horns. I don't remember hearing horns. I remember hearing ambulances, fire trucks, police, sometimes the supporters cheering, depending, but more so it's ambulance, it's fire trucks, and law enforcement. Uh, what are they talking about? This is yet more misrepresentation, more exaggeration on the Commonwealth's part. But where an individual refuses to comply, officers need to be able to use reasonable physical force and to make an arrest to ensure compliance with the order and to avoid jeopardizing their own safety and that of the public. The order itself may provide that authorization. Commonwealth versus Williams, Commonwealth versus Garner. In parentheses, courts may authorize law enforcement personnel to use reasonable force to carry out law orders, and courts are not constitutionally required, quote, to prescribe with exactitude the particular degree of force to be used, end quote, in carrying out orders. That is a bit concerning, guys. That is a bit concerning. Do you guys see it? Courts may authorize law enforcement personnel to use reasonable force to carry out lawful orders, and courts are not constitutionally required to prescribe with exactitude the particular degree of force to be used in carrying out orders. This motion is citing a case law that gives law enforcement legal authority to do whatever the hell they want, because constitutionally it's not required of courts to prescribe with exactitude the particular degree of force to be used. In essence, it is saying we can use whatever force we want to use and the court doesn't have to prescribe it. Like, how does that make sense? They want to lock up more Karen Reed supporters. They want to lock up more people who know she did not do this. Guys, if you didn't know, Massachusetts is where police departments started. Massachusetts is where it started in the US. And then after that came New York City and Chicago. But Boston, Massachusetts had the first official police station, police department in the US. Boston, Massachusetts is the birthplace of police departments in the US. And at first it was about protecting capital. At first it was about keeping the poor away from the wealthy. At first it was about letting the wealthy keep their belongings and making the poor stay poor and out of the wealthy's environment. And then it progressed. It progressed to other things, and then racial issues occurred as well. Again, I've recommended Trial 4 on Netflix, and which involves an African American who was framed for the death of another Boston police officer. The Irish had a bad time in Massachusetts. There was a lot of racism against the Irish in Massachusetts. It's funny I'm making this video on St. Patty's Day, but there were plenty of other racial issues in which law enforcement had a direct role in. And I'm not here to say that every officer is bad. I'm not here to say that every officer has an issue with power. But I am saying that this is the birthplace of police departments. And if we look at what has happened in the Karen Reed case, we see blatant corruption, in your face corruption involving multiple members of law enforcement, multiple police departments, all the way up to the Massachusetts State Police, as well as lawyers and judges, also corrupt in this case. So when you already have a corrupt institution, a known corrupt institution like law enforcement, like police departments, and this is the birthplace of police departments, and then you have documented corruption from the prosecutor's office, in this case, in Norfolk County, and then you have a judge who is proven to have a conflict of interest with the district attorney in Norfolk County, and a judge that goes above and beyond to side with the prosecution every chance she gets. What you have is that the birthplace of law enforcement in this country isn't doing so well. And it's not setting the precedent that I think a majority of us would want in this country. It's not doing so well. It's actually rotting from the inside out. The rot is festering in Norfolk County. It is festering in the Boston PD. It is festering in the Canton PD and in the Stoughton PD. They are all connected to this case. And this order that we are reading together, is further demonstration of that power. It is showing us that law enforcement and the judge and the attorneys, the prosecutors, are working together to put someone away who is provably innocent. And this, guys, this has nothing to do with politics. I've noticed the comments I get sometimes on these videos. People like to make it about who's president or who's the political party in power. Has nothing to do with it, especially if you understand the history of this country. If you understand that it didn't matter who was president, law enforcement in this country became increasingly powerful every decade. It did not matter who was president, guys. Every president gave law enforcement an increased amount of funding and an increased amount of power over the decades. A lot of money goes into our police departments every year. But when you've got police departments here in the Karen Reed case, and judges in the Karen Reed case, and attorneys, prosecutors in the Karen Reed case, who are all working in unison, demonstrating and displaying their corruption and putting it on paper that they can do this, they can write it down in an order and the order is enforceable. All Judge Bev has to do is sign it. This motion isn't just about keeping the supporters out of the area when trial is happening, it's also a scare tactic against the supporters. It is a scare tactic using the power and the brute force of law enforcement and the criminal justice system. It is giving them license to lock people up whom they don't want to hear from. And it's not okay. Again, has nothing to do with politics and has everything to do with a rotting system. And you best believe Boston is not the only place. Canton, Massachusetts is not the only place. This is happening in plenty of other police departments, plenty of other jurisdictions across this country. Unchecked power. Continuing. For these reasons, the Commonwealth respectfully requests that the court allow this motion and issue an order with the following or substantially similar terms. The court hereby establishes a buffer zone around the courthouse complex during retrial of this case. This complex includes the Norfolk Superior Court House building and the parking area behind the Norfolk County Registry of Deeds building. The buffer zone extends 200 feet from the courthouse complex and further includes the area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. No individual may demonstrate in any manner, including carrying signs or placards, within the buffer zone unless otherwise ordered by this court. Individuals are also prohibited from using audio enhancing devices while demonstrating. No individual will be permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the retrial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department issued uniforms or any police emblems in the courthouse. A violation of any provision of this order may constitute contempt of court. Court officers may eject or exclude entry to any person believed to have violated the provision against wearing or exhibiting certain clothing or items in the courthouse. Any person believed to have violated the buffer zone provision of this order and who has refused a prior verbal request by law enforcement personnel to comply with that provision may be subject to arrest. Law enforcement personnel may use reasonable force where necessary to compel such person's compliance with that provision. Respectfully submitted for the Commonwealth, Hank Brennan, Adam Lally, Laura McLaughlin. So no Michael Morrissey in this one. Dated March 17, 2025, certificate of service, served to the defendant via email today. So again, guys, this motion is an abuse of power. It's an abuse of power. It's an abuse of the First Amendment. And it's a further abuse of justice because when you've got people who are dedicated to this case, you've got people who've been following this case for years now, and you've got documented fucked up shit over and over again. Like, again, no chain of custody for anything, botched timelines, no matter which timeline they're referring to. The cell phone extractions that the prosecution relied on were not even hash verified. The inverted video, the fact that Karen Reed drove her SUV past multiple homes and multiple businesses, but not one video, guys, not one video was recovered showing Karen Reed's rear passenger side taillight before they took it to the Sally port and fucked with it. Guys, not one video, right? But look at this. The prosecution can make an order surrounding the courthouse in Dedham, right? They can ask for hundreds of feet of security surrounding the courthouse here, right? hundreds of feet to keep the protesters out, to keep the supporters out, but they couldn't do that the morning of January 29, 2022. That they couldn't do that. They couldn't ask for an order saying, can we please get a search warrant for everyone living in this radius so we can access their ring cameras or their security cameras so that we can determine how Karen Reed's taillight really looked that morning before her SUV was taken to the Sally Port? Or the opposite, like people driving to 34 Fairview, all of those people, the McCabe's, the Alberts, Brian Higgins, all of them, you know, no video footage of them getting there, no video footage of them leaving there. And remember, guys, that video footage of Brian Higgins talking on the phone at 1:30 a.m. at Canton PD, that was given to the defense team within the last few months. It it's been in the prosecution's possession all this time. The defense wasn't even able to question Brian Higgins about it during the first trial because they weren't given the video footage until a couple months ago. So they will secure the area. They will want an order securing the area around the Superior Courthouse in Dedham, but they don't want to secure the area when it comes to proving or disproving who did this to John O'Keefe. They want the license to keep lying. They want the license to keep being corrupt. They want the license to keep ruling the narrative, but they don't want to actually solve this case. They're not going to win. Even if Judge Bev grants this motion, they're not going to win. I do not see them winning with this. I see uh other members of the legal community coming in to fight this motion too. The ACLUM stepped in. I could see them stepping in again because of this motion, and possibly other interveners, other third parties who are like, fuck this. If we allow this to happen in this case, it's going to set a precedent for other cases. The next time Norfolk County wants to frame somebody for a crime they didn't do, all they have to do is refer to this bullshit motion from Hank Brennan and Adam Lally and McLaughlin and say, hey, Judge Bev granted this for them during the Karen Reed case. So let's do this again for another case. And then what, guys? The state always wins. The law enforcement always wins. Corrupt institutions always win because they have successfully left the supporters out. They have successfully silenced the truth sayers. No, they're not going to win this. They're not. I look forward to the legal community's response to this bullshit motion. Good luck, prosecution. Thank you all for watching.